Good day everyone, welcome to another episode in our What If series, where we bring you insights in the format of a what if question on the ever-evolving landscape of employment law. I am Ross Simon from Maserumule, and in today's episode we will unpack what if an employee alleges that the termination of their fixed-term contract constitutes a dismissal. What are the applicable legal considerations and implications? A fixed-term contract from an employment law perspective can succinctly be defined as a contract of limited duration that terminates upon the occurrence of a specified future date or event. As the fixed-term contract terminates automatically by a fraction of time and not at the instance of the contracting parties, the termination does not constitute a dismissal. The recent decision in the Labour Court matter of Mugabe vs. Beteract Holdings and others provides practical guidelines in determining whether a fixed-term contract is terminated or a dismissal has taken place. These guidelines have been incorporated into a two-stage inquiry where Stage 2 has its own unique steps. Stage 1 of the inquiry entails a multifaceted analysis to properly exercise a value judgment as to whether the automatic termination amounts to a dismissal. In this regard, one is to consider whether, on the facts of the matter, enforcing the automatic termination clause, for example, finding that no dismissal occurred, would unfairly deprive the employee of the right not to be unfairly dismissed and the right to challenge the fairness of a dismissal. Stage 2 is broken down into 5 steps. Step 1 requires the consideration of the employment contract. The wording and nature of the employment contract should be tested against the following questions. Is the duration of a specified period? Is the duration and termination of the employment linked to the attainment of a particular goal or the happening of a particular event, which can be objectively verified? Is the contract of employment read as a whole, intended to, or does it have the effect of seeking to bypass the statutory protections against unfair dismissal and or the right to challenge the fairness of a dismissal? And is the termination clause triggered by the exercise of a client's will or at a client's discretion? Positive answers to the first 2 questions would indicate the presence of factors that weigh in favor of enforcing the terms of the employment contract, while negative answers would have the opposite effect. Positive answers to the 3rd and 4th questions would weigh against upholding the automatic termination clause and vice versa. In a temporary employment service scenario, the contract between the employer and its client may also need to be considered, particularly if it provides for termination or reduction of services at the instruction of a client. Step 2 is to determine whether Section 189 of the Labour Relations Act applies. If so, the factors and requirements listed in the relevant sections should be considered and applied where necessary. If any of the deeming provisions in the statute are found to apply, this may have the effect of short-circuiting the inquiry, as the value judgment to be applied is effectively codified in the relevant statute. Step 3 is to consider what event or events triggered the termination of the employment contract and whether they are justified by objective and proper and economic considerations. The closer the trigger event for the contractual automatic termination is linked to the occurrence of an objective and objectively determinable event, such as an agreed termination date or the completion of the project to which the employee was assigned, the more likely it is that the enforcement of the automatic termination clause will not result in an unfair infringement of the employee's right not to be unfairly dismissed. At the other end of the spectrum are the cases where the trigger event lies in the sole judgment or discretion of a client. Termination of a particular employee's contract at the behest of a client is likely not to pass muster as a valid automatic termination of employment and is more likely to constitute a dismissal. In between these 2 spectra would be cases where a client or employer has the discretion to trigger the automatic termination clause at the time of its choosing. Step 4 requires one to consider the effect of upholding the automatic clause on an employee's statutory rights. One should consider whether enforcing the termination clause in the circumstance of the case and on the application of the above factors would unfairly restrict the employee's right to fair labor practices, the right not to be unfairly dismissed, or the right to challenge the fairness of a dismissal. Step 5 requires one to consider other issues that may affect the final determination of whether a dismissal occurred. For example, whether the employee claims a reasonable expectation of renewal of the fixed-term contract, whether the employee claims that the decision to terminate was tainted by bias or other improper motive, or the employer engaged others to perform similar work after the termination of his or her contract. Colleagues, these steps and factors are intended to provide practical guidelines as to whether a dismissal has been established. They are not to be construed as a closed list or as definitive. Each matter must be determined on its own particular facts and circumstances. That brings us to an end of this week's episode. Thank you for joining us. We hope you have found our discussion informative. If you have any questions or comments, we'd love to hear from you. You can find us on social media, or you can email me at ross@massconsulting.co.za. Until next time, bye-bye.